Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. I'm your host, Ron Glick. Tonight we're going to be talking about grand juries. Now, I know I've already talked about grand juries versus the use of informations in a previous podcast, and there will be some overlapping. But this is more about the subject of the idea of the oversight capacity of a grand jury and reasons why people like Mike McGrath don't want grand juries to exist. But before we get started, if you're watching this on YouTube, please take the time to like and subscribe. Make sure you watch this video to its full end, and of course, share with as many people as you possibly can. The more people we have watching this, the more information we get out there, the better chance we have of affecting change. As always, if you do not see any content attached to this video, please visit our original site, which is monspiracy.podbean.com. If there's any text that was excluded in the video which you're watching now, it will be attached there, and of course it will be on YouTube. Now, like I said, talking the last couple of episodes about Mike McGrath's claim got me thinking. Now, for anybody who's not watched the previous podcast, he claimed in an interview, or before a judiciary review panel set up by the Montana legislature, he claimed that citizen oversight would kill democracy. Now, it's a laughable concept for any official operating in democracy to say that citizen oversight would kill democracy. But it reminded me about one of the things players in the Great Montana Conspiracy took away from us, took away from the citizens of the state of Montana, and that was grand juries. Grand juries exist as checks on government abuse. It's historically speaking, that's why they existed. They existed to prevent prosecution and massive arrests and abuse of power by government against citizens. Citizens, as a necessity in a democracy, must submit to the form of government. And honestly, even in a monarchy, that's the case. Anyone who's ruled by a government, regardless of the form it takes, consents to that form of government. If they do not consent, they rebel, they rise up, they fight back. The American Revolution is how the American democratic experiment actually came to be, was because we did not agree with the way that England and France and other countries were controlling the colonies that existed here in the Americas. So the idea that you're submitting to the form of government that you live under is a predominant issue. Now, we can argue that monarchies often take the power away from citizens. They, especially in modern day with modern day warfare, with heavy artillery and guns and weapons, and they minimize the capacity of the people to rise up. But regardless, rebellion is a form of expression against and fighting back against the kind of government you do not want. In the case of a democracy, where the people consent by virtue of having a right and say in how the government is formed, how it acts, and yes, oversight of that government, it becomes necessary for things like a grand jury to exist, and that's why that exists. They exist as checks on government abuse, both to hold government officials accountable and to make certain that government does not abuse its power over its citizens. The grand jury exists in American law for this reason. Yet people like Mike McGrath have completely shut down the right. Players in the Great Montana Conspiracy have shut down probable cause hearings, grand jury determinations. They hold people under excessively high bails under cruel and unusual circumstances. They literally threaten and terrorize people until they bend and break and take plea bargains so they don't have to take them through the jury system, which is another topic I need to hit on and talk about why juries are so critically important and how we need to reinstate them and outlaw the plea bargain. It's obviously, there's so many issues I need to talk about, but let's try to stay focused on the grand jury tonight. I'm getting a late start tonight because I've had some technical issues on this end. I lost a laptop, power unit was down. It took me a while to get the backup laptop conformed where I could use it, and as a consequence I'm starting this very late. And of course starting it late means I have to try to get this done and recorded and in the bucket, if you will, in a shorter period of time. So I'm going to try to breeze through this and try to stay on top, as close to on topic as I can tonight. Now, as I mentioned, I've already done one episode discussing the grand jury versus the information. You do need to make sure you watch that one because it's critically important as the foundation to this episode. I will be making some efforts to try to cross-pollinate, but it is critical to watch that episode. This one is more of a reasoning for grand juries as opposed to, and of course, the accountability for government and oversight and protection of citizens' rights than it is against the method of prosecution. As I said, grand juries were designed to prevent abuse of power. Remember, McGrath said that citizen oversight would be the death of democracy. The founders of our country put citizen oversight rights right there in the Bill of Rights, in the first 10 amendments of the Constitution. It was so important that when the states were presented with the Constitution back in 1787, there were states that would not ratify the Constitution because it didn't have any content for the Bill of Rights, for the rights of the citizens. These were so fundamentally important that the states would not ratify and form a collective government if they did not exist in the Constitution. It required Hamilton to go back and write, and first of all, agree to do this to get the ratification. And once the first Congressional Congress was formed, he set out about doing it. The states demanded the Bill of Rights be put into the Constitution. And to give you an idea, the ratification of the U.S. Constitution was in 1787. By 1791, the Bill of Rights were in place. 10 amendments right off the bat in the first 4 years of our country, or first 4 years under the Constitution. We had a former Constitution document that we had that just collapsed, and that's a discussion for history, but we'll leave that alone for now. Again, I'm trying to stay streamlined because I tend to get off topic pretty easily. But let's stick to the topic. So critical were these rights, the states would not ratify the Constitution without a promise and an assurance of these rights we put in. And one of these rights, the critical right, was grand juries. Now, remember, grand juries are not just, let's go take an accused person and find out whether they've committed a crime. Obviously, it's an essential portion of the grand jury function. But more importantly, it exists because it prevents the government from just unilaterally arresting people and throwing them in jail without a probable cause hearing, without any kind of oversight, without citizens being able to say whether or not what the government is doing is just and lawful. Remember, I got thrown into jail on a warrant that was not even filed with the court until 4 days later. It was a fake warrant. It wasn't signed by a judge. It was entered into the court, date stamped at 4:44 in the morning. It was not filed in the court itself until 4 days later because Lori Adams, the prosecutor and now municipal court judge of Kalispell, took those documents out of the court and put them on her desk and kept them there until they found out they actually had arrested me under the warrant. Then she had to go back to court and file them 4 days later. So if a grand jury had existed, this would never happen. She could not have created a fake prosecution because the grand jury would have to have reviewed the information and issued an indictment. And the indictment would have been proper. She couldn't have faked 12 people and created an indictment for a grand jury that didn't exist. But because there was no grand jury, there was no checks and balances, there was no issue of whether or not there was citizen oversight, her as a government official could walk into the courtroom at 4:30 in the morning and start preparing documents, start filing them, so that she had them in place to send to Washington State to try to intimidate me to not return to Montana. So what you have here is an example of how the grand jury is a critical and essential element to curbing government corruption. Absent a grand jury oversight, government can arrest people and throw them in jail on any whim they want to. It happened to me, it could happen to you, it could happen to anybody. This is why I'm a political prisoner in Montana, because this kind of corruption exists, because grand juries don't exist in Montana. Now, historically, grand juries were originally only applicable to the federal system. the founders set up the idea that they did not want a centralized government. Well, we've gone way far and abroad of what the founders originally intended for our country. The federal government is far more powerful and overreaching than they ever intended. But the initial intention of the Bill of Rights was to prevent the central federal government from overreaching upon the citizens' rights. For some reason, the founders didn't perceive the idea that the states would. They believed the states would somehow preserve the rights from a centralized federal government. Obviously, Montana is a perfect example of how that didn't work. But this all changed with the passage of the 14th Amendment. The 14th Amendment said, very specifically, that no state shall deprive any person of life, liberty, or property without due process of law. Which meant, and of course it also set forth, that the states could not deprive any citizen of the United States of their rights under the federal Bill of Rights. So you essentially have language in the 14th Amendment that binds the states to the federal Bill of Rights, to the federal Constitution. Now, this set the foundation for states to be held under the Bill of Rights, but it took a little bit longer for that to happen. 200 plus years later, since the passage of 1787 was the passage of the Constitution, 1791 was the passage of the Bill of Rights. We're over 200 years, 230 some odd years later, we still have, everyone seems to have forgotten all about this, we still have problems that these essential rights were designed to prevent. Americans seem to have let government officials do anything they want. They seem to have gotten complacent with the idea that they're government, therefore they're bound by laws, and therefore they wouldn't do it if they couldn't do it. Well, they do it because nobody tells them they cannot. This includes violating the very restraints designed to keep them in check. Absent citizen oversight. Absent citizen oversight. I'm going to say it again. Absent citizen oversight. Citizens are essential to reigning in government, because if citizens don't reign in government, this is what happens. You have the Great Montana Conspiracy. You have a corrupt government that exists to the very foundations, and nobody stops them because everyone says, well, they wouldn't do it if they couldn't legally do it. The number of times I have been told, I tell them that the prosecutor went in at 4:33 in the morning to file these paperwork, and at 4:44 issued a fake warrant that never had a judge's signature, never had any authorization, and she took it out of the courtroom and she put it on her desk. And she held it there because it was a fake prosecution. It wasn't a real case. And the number of people who keep saying, like, she couldn't do that. There must be something else you don't understand. No, I'm telling you exactly what happened. No, they can't do that, but they did. But they can't, but they did. Over and over and over again, this argument goes back and forth between thousands of people and myself. People telling me what the government cannot do, and me insisting that's exactly what they did. How'd they get away with it? Because nobody stopped them. And here we are. Specifically speaking, I'm going to talk a little history of the grand jury, why the grand jury is important. It has its roots in English law. Now, anybody who understands the United States understands that the United States laws were primarily, founded upon and modeled after English law. With the grand jury and other implements of democracy as we know them in our Bill of Rights started with the Magna Carta, which was signed originally in 1215. A government exec at that time, the kings, would arrest barons and lords and anyone else they wanted the property they wanted to claim or put pressure on. They would arrest their children, they would arrest whatever they needed to do to put pressure upon barons and landowners to do what the king wished them to do. Or if they simply didn't like, if they were decided to stand against the king, they'd arrest them and throw them in jail just indiscriminately just because he was the king. And at that time it was perceived as that he had the divine right. He was appointed by God to rule. And therefore, through his divine power and his divine right, he could do whatever he wanted to do. So the barons were threatening to do an uprising, to have an uprising in England in 1215. And therefore, the king came together, the king came down and said, okay, we're going to go ahead and agree to this. And the Magna Carta was signed. And I'm being incredibly, incredibly brief. in this because the Magna Carta has its own history, it's very significant history. It's not as simple as it was signed, it was followed. It was signed, it was withdrawn, it was ratified, it was withdrawn. People did, I mean, it's back and forth. It was incredibly, conflictive and problematic. The war that was designed to stop didn't get stopped. The War of the Barons still happened. There's an incredible amount of history to the Magna Carta that I'm going to skip over just to make it easier for this podcast. If you're interested in the subject of Magna Carta, please look it up. It's an incredibly interesting history, but it is far too extensive to talk about in great detail here. But as I said, it was initially entered into and agreed upon to stop the uprising of the barons who were serving under the king. And it eventually led to government oversight of government, which, again, this did not happen overnight. It wasn't like they signed it. The very next day, they voted in citizen government, and that's the way it worked. To this day, we still have English monarchs because the monarchy still exists. But we have a House of Lords, we have a House of Commons, we have all kinds of democratic rights in England, and this is where the foundations for the right of the belief in the foundation that American justice was founded upon. As I said, this is an incredibly oversimplification. There's far more history, but it's just the basics. But the principle remains sound. Left unchecked, government will abuse its power. Citizen oversight is necessary to prevent this. It was agreed upon in English history. It became a foundation in English law. It became a foundation of American law. And as I mentioned, the states would not even ratify the Constitution if they did not have guarantees that these very restrictions upon liberty were not put into the Constitution or amended to it to make sure that government didn't have the power to breach it. In fact, the first grand jury was formed in the reign of Henry III, who took up the reign from 1216 through 1272, the year after the Magna Carta was signed. It was accepted as a common law of practice by 1787, when the Constitution was passed, when the U.S. Constitution was ratified. It was so instrumental, so critical as a right and a liberty, that the states, all 13 colonies, needed to be on board with including the Bill of Rights, or else the majority would not come together and form the United States of America. We would not have a country. We would not have a constitution if these rights were not agreed to. That's how important they were to the founders of our country. They were so critically important, they literally refused to form a government without them. They refused to ratify the Constitution if a promise and a guarantee was not made that the Bill of Rights would be created. And it took 4 years to get it written, passed around. And keep in mind, we didn't have email, we didn't have internet, we didn't have the ability to telegraph things back then. It was all, let's put papers in a satchel and ride them across town on a horse. Or across the country in this case. And we're talking from Rhode Island all the way down to, the South and the southernmost colony, South Carolina. I don't remember. But regardless, the whole point being, we had a massive problem with transit. Of course, we had weather inclement conditions. Winter was next to impossible for passage in a lot of areas. So reaching and getting everything ratified and then return to Washington, D.C. wasn't exactly as simple as sending it off, giving it a couple weeks to review, and then send it back. Didn't have a U.S. postal system back then. Didn't have any kind of electronic signatures, fax, anything. So it took time. 4 years was an incredibly abbreviated period for the period of history we're talking about, and forms such a critically elemental force of power in our government. So, the Bill of Rights protected things like freedom of speech, religion, protections against cruel and unusual punishment, excessive bails, etc., etc., etc. And instrumental amongst this was the grand jury. Every person who's accused of a crime has a right to have the citizens, his peers, review whether the government is proper in bringing the charge. That's a critical element. This is an element that was absolutely essential to forming our country, and yet our government, our president in Montana, has basically outlawed it. It exists on the books, but it's never called upon, because they create a far more expedient method called the information. All of these issues remained as a restraint upon government from doing the very things it's doing. And it's doing them because people sit back and let them do it. Remember, Mike McGrath sat there at this hearing in front of the state legislature and argued for an independent judiciary. A judiciary that was not answerable to either other branch, that was completely autonomous, that didn't have any oversight, citizen or other branch government either way, and actually said that a citizen oversight of the judicial branch would represent the death of democracy. No, it means the death of his corrupt power, but that's not democracy. You can call it whatever you want. That's not democracy. Totalitarianism is not democracy. Monarchy is not democracy. Tyranny is not democracy. And that's what Mike McGrath wants to run. As I mentioned in my last podcast, Mike McGrath believes he's the head of the state of Montana. He believes he runs the whole thing, and he's right so long as the judiciary remains independent, because he is the head of the judiciary, and he has power over both branches, has power over every citizen in the state, has power to do whatever he wants, whenever he wants, without accountability. You're right. He's usurped all power in the state. He is essentially the unofficial shadow ruler of our state, because he doesn't want oversight. And if he succeeds in getting at that, he is unchecked in his power. Power corrupts. Absolute power corrupts absolutely, and this man is absolutely corrupt. And when he sits there and says, he can say that with a straight face, that citizen oversight will kill democracy. You have to see that. You have to. How can you look at anything and say, one man deciding that the judiciary needs to be independent without any oversight, any accountability to any of the other two branches, no checks, no balances, and has power, absolute power, over all of the branches of government, all the citizens of the state? At what point does that not become a tyranny? The only thing he doesn't have control of is the armed forces. As I said, in Montana, this is simply not done. You don't have the protections of the rest of the country. Obviously, I don't. I spoke out against the government and I got thrown in prison for it. My rights to civil liberty, due process of law, everything thrown out the window because there was no government oversight. The foxes cannot be asked to guard against the other foxes, to keep the other foxes out of the hen house. I keep using that analogy, but it's absolutely 100% true. When you have corrupt officials, you cannot ask corrupt officials to guard and protect against other corrupt officials. It just doesn't work that way. And yes, as I mentioned, this is going to be a little overlap for the older episode. But in Montana, there are no more grand juries. The law exists on the books. It has been supplanted by the information system. And the information system is simply and literally nothing more than a prosecutor signing a piece of paper, saying a crime was committed, submitting it to the court, the judge signs it, the person's arrested. That's it. There's no probable cause hearing in Montana. You don't get a chance, even after arrest, to show up and have a probable cause hearing to determine whether the facts against you constitute an actual crime. You sit in jail under an excessively high bail. $10,000, $50,000, $100,000 are not uncommon bails in Fayette County. You sit there until you break and you agree to take a plea bargain, because you sit there and you're terrorized. You're losing your home, you're losing your family, you're losing your job, your income, your resources. If you have any resources, you're dumping it into a legal defense. 90% of the people in the system are represented by public defenders who don't, because they don't have money. You wonder why elitism exists? Because the rich don't face criminal prosecution 90% of the time. The poor do. And the prosecutors don't care. They want to dump. The more poor people they can dump in, the more they overburden the public defender system, the more they make it impossible for these people who have no understanding of the law to defend themselves in a criminal prosecution without an effective assistance of counsel. It makes their job that much easier. The state of Montana relies upon, and again, this is talking about information that was in the last episode, but or in the episode I'm talking about, the grand juries versus information, but it's important to understand the foundation of where I'm going. Montana relies upon an 1884 Supreme Court case to provide authority. It's called Hurtado versus California. And for reference, that's 110 U.S. 516. But what Montana ignores is that this case, Hurtado, was actually I can talk tonight, honestly, ladies and gentlemen. It is subjectively overruled by a 1925 case called Gitlau versus New York. And that's 268 U.S. 652. In Hurtado, the U.S. Supreme Court was looking at the issue of due process. California had adopted an information system. And remember, at that time, the states were not bound by the federal Bill of Rights. Therefore, they were not required to hold their citizens accountable under the Bill of Rights. They could create whatever information and prosecution system they wanted to create because they were not prohibited from doing so prior to the passage of the 14th Amendment. The 14th Amendment specifically put within it language that compelled the states to not violate U.S. citizens' rights. And every member of a state is still a U.S. citizen, and therefore subject to U.S. citizens' rights. Hurtado argued before the U.S. Supreme Court that California's implementation of an information system denied him his right to a grand jury. As a U.S. citizen, he was entitled to have his charges brought before a grand jury before being prosecuted by the state of California. The U.S. Supreme Court concluded this was not a deprivation of due process. They argued that essentially due process required that so long as a system existed to allow for probable cause challenge, expanding the probable cause right, the right to challenge probable cause after arrest, still constituted due process. He still had the right to face his accusers, had to review the information, and have it considered by a judge. Obviously, I consider that a horribly bad decision. It bypasses the necessity of citizen oversight. It puts the judgment for a single judge who often is allied with the prosecutor, and therefore it's automatically a bias and pre-existing bigotry existing within the court against the criminal defendant. And oftentimes, at this stage, you don't really have the right to have any kind of proper representation. At this stage, the earliest stage, a defense lawyer is lucky to have the information given to them by the prosecution, much less being able to actually go through and actually interview people themselves and determine whether or not there's actually any disputable issues in the charges. And the prosecutors are only going to turn over whatever they want to turn over. This is long before Brady law and the requirements that the courts or the prosecutors have to turn over any exculpatory information. And that, by the way, is Brady versus Maryland, which is another case entirely, and I've talked about it before on the podcast. But in essence, in 1884, the Supreme Court decided that states it wasn't depriving an individual due process to deprive them of grand jury. It just, so long as they had the right to challenge through a probable cause hearing the evidence against them. But what the High Court did not do was discuss the full language of the 14th Amendment. It specifically overlooked the language that applied directly to the states. Specifically, that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Those privileges and immunities are the Bill of Rights. The Bill of Rights are the essential core civil rights of citizens of the United States. The 14th Amendment specifically prohibits the states from making or enforcing any law that would abridge those privileges. Therefore, the court in Hurtado, by disregarding this language, choosing to disregard this language, because actually the dissenting vote in the case actually brought up this exact argument. That the court was looking at the wrong area of the 14th Amendment, challenging whether it was a due process issue, instead of addressing the issue of whether or not the state could even legally form the law or enforce it. This language was a specific prohibition against the states depriving the civil rights of individuals under the federal Constitution, which included grand juries. By deciding on the issue of due process, it bypassed entirely the necessity of ruling on the other issue. It ignored the directives forbidding these state actions. But even in Hurtado, the court believed based its decision on the belief that a probable cause hearing existed that allowed a defendant to challenge the facts of a case brought against them. Remember, Montana has cast this aside as well. You do not get a probable cause hearing in Montana. You get charged with information, the judge signs it, you go to jail, and then you wait. You have a first appearance where you get to plead guilty or not guilty. You have a status hearing where you determine whether you're going, have your trial date set, whether you're going to court, whether there's any change of pleas. But you don't have you never have a chance to challenge that information until you go to trial. In my case, it was 18 months. 18 months before I saw a trial. I sat in jail, in custody, for 18 months. No probable cause hearing, no grand jury investigation, no ability to challenge the information brought against me, to challenge the so-called evidence, any of it, for 18 months. And then I was put before a kangaroo court and prosecuted. It's another story for another day. I'm trying to stay on focus here, ladies and gentlemen, as I'm obviously not very good at that. There's so much to talk about. There's always so much to talk about. So much more than just the script I have in front of me. So much more than the information and the subject of the podcast episode I'm going with. So please forgive as I divert a little bit one direction or another. But I'm trying to stay focused tonight. Anyway, in counterpoint, in GitLoud, the U.S. Supreme Court took up the proper language. In 1925, it ruled the incorporation language applied the Bill of Rights to the states. Remember, the incorporation language is no state shall make or enforce. That's the incorporation language. It specifically said, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Once that language is in the 14th Amendment, it is there. This decision soundly trumps the subjective language of Hurtado, because it says that all rights of the Constitution that apply through the Bill of Rights apply through the 14th Amendment to all citizens of the country, regardless of what state they reside in. It says that states cannot deny any right of a U.S. citizen, including grand jury. Now, they don't specifically talk about grand jury. They're talking about First Amendment freedom of speech. But nevertheless, it states very clearly and very succinctly that the states are bound by the Bill of Rights through the 14th Amendment. They can't deprive any right to a citizen if it's in the Bill of Rights. The point is that people like Mike McGrath grasp onto decisions like Hurtado. It's bad law. It's been subjectively overruled, yet it gives them a foothold. Because the scholars have not said specifically that Hurtado has been overruled, therefore, because technically, GitLoud didn't talk about due process. It talked about whether the Bill of Rights was applicable to the states, whether the states were forbidden from depriving people, the citizens of the states, the rights they had as citizens under the federal government. So because GitLoud didn't specifically talk about Hurtado, didn't specifically talk about Hurtado, didn't specifically talk about due process, it technically does not directly overrule Hurtado, but it does subjectively overrule it, because it says, it basically says that California's institution of an information system was unconstitutional because it did in fact deprive Hurtado of the right to grand jury, which is a right under the federal Constitution which the states cannot deprive. They cannot make laws nor enforce laws that take away any civil right guaranteed under the Constitution. And the right of grand jury has never been stripped from the Constitution. It's never been amended away. The language has never been changed. The grand jury exists in the federal Constitution. The 14th Amendment exists and says the states are bound by it, and therefore the states cannot deprive a grand jury. And the 1925 state case is correct. And therefore, subjectively, it encompasses all rights under the Bill of Rights, and it includes grand juries. But Montana doesn't want to pay attention to get loud because there's a Supreme Court case that says they can use information system. The problem is they're not even using the information system that the United States Supreme Court said was acceptable because they don't have probable cause hearing. No criminal defendant has the right to challenge any information, any evidence, anything until they see trial, however long that is. I sat in jail under a $50,000 bond I could not possibly raise for 18 months before I saw a trial. 18 months I waited. Throw out any concept of speedy trial rights or any concept of due process, right to challenge your accusers, all of that. I had to wait 18 months for it. 18 months while the state sat there and harassed and terrorized people on the outside. I was cut off from all resources, all communications. I was imprisoned for 18 months for a crime of which I was not convicted. And I had no capacity to challenge. And it can happen to anyone. It happens to people all the time. Why do so many innocent people fall to this system? Because they make it impossible to challenge. And again, you can sit here and say, but they can't do that. But they do. That's my point. They do, and they keep doing it because sitting back and saying they can't do it has no effect. Citizens must be able to oversee the government, must be able to challenge the actions of the government, or the government is no longer a democracy. The point is that people like Mike McGrath, they're power hungry and they'll use any excuse they can to hold on to power. And again, Mike McGrath thinks he is in charge of the entire state. He believes he's entitled to it by right of virtue of being the head justice of the Supreme Court. Because he thinks that the court system should be independent without oversight. He thinks oversight will kill democracy. It won't kill democracy. It'll kill your power. It'll take away your power. It will not kill democracy. In fact, it will repair and restore democracy. Regardless of the fact that Hurtado was bad law and has been subjectively overruled, it gives people like McGrath a foothold. By using information instead of a grand jury, it provides 3 critical benefits. Benefits that the founders of our country forbid the government from ever having for a reason. They had suffered horrifically under this abuse. Previously, the Magna Carta was signed because kings had this abuse of power over barons and landowners in England in 1215. When we signed the Declaration of Independence in this country in 1776, it was because we had suffered under the same abusive concept, because at the time our rights as English citizens, French citizens, whatever, we were in the colonies and we could not get enforcement of our own rights. Therefore, we had to rebel. We had to have a revolution. We had to break away. This is the result, was forming a government that specifically prohibited this kind of abuse. And yet, American citizens are allowing this to happen. It's ongoing. It's problematic. But like I said, they prevented this for a reason. The first ability it gives corrupt officials in Montana is it gives unrestrained power to prosecute anyone at any time. It shuts down any opposition, political or otherwise. It shuts down anyone who's seen as undesirable. Essentially, it creates the political prisoner power under which I am restrained. The second is it gives them the power to mass prosecute. It keeps prisons full so that the state can apply for federal block grants. Billions of dollars in federal block grants. It maximizes incarcerated by minimizing the ability for them to defend. It massively augments the grant funds that states can receive. It essentially empowers the prison for profit system. And third, and the most critically important to people like McGrath, that he really doesn't want this kind of oversight, is it bypasses their own accountability. It bypasses the accountability of McGrath. It bypasses the authority of people like Lori Adams and other, Heidi Albright, Judge Bob Allison, you name an official who's abused his power, and this is the kind of thing you have to stop it. Because foxes will not guard against foxes. Corrupt officials will not guard against other corrupt officials. Citizens cannot bring prosecutions against anyone. I, as a citizen, cannot prosecute. I can sue somebody in the civil courts. I cannot bring a criminal prosecution, even though that requires the government. The government is the only one who can bring a criminal prosecution against anyone. And especially, it brings, if you have corrupt officials, they're not going to bring charges against other public officials because they are protecting each other. In a good old boy system, prosecutors will not prosecute their own. They will not prosecute members of the good old boy system. They will not prosecute anybody who is their ally in maintaining the corrupt power, in maintaining the regime. Citizen oversight is the only way to put these government officials in check. And it's the very thing the government officials are fighting against. Remember what McGrath said, how citizen oversight would kill democracy. He has certainly gone a long way suppressing it, calling for an independent judiciary, helping to suppress rights such as those held by grand jury, which at its core is citizen oversight. It is 12 to 23 people, however many the court assigns, citizens, normal people, who have the ability to ask questions and determine whether the government's choice to prosecute and charge a person is legitimate. There is no legitimacy to the process as it stands right now. Mike McGrath and every other corrupt official in Montana is afraid of citizen oversight. Afraid of things like grand jury, afraid of a citizen-supported Judicial Standards Commission. Anything that gives the power of the people to the people over government. They're afraid of it because it means their own criminal misconduct can be challenged. Power corrupts, absolute power corrupts absolutely, and if they absolutely get their way, we have no power. They take away our rights step by step all along the way. Of course, even when due process remains, even when things like grand juries exist, there are problems. Essentially, I mean, you're still talking about a criminal justice system and laymen who don't understand the law. Prosecutors often become the sole party representing evidence to a grand jury. They decide what to bring. They put the information slanted the way they want it slanted. They're the ones who are instructing and directing the grand jury on what they can and cannot do. They often are the ones who are making decisions, honestly, through their influence about whether to even seek additional information. Most of the time, the grand juries are not truly independent, even though the auspice exists that they're supposed to be. The prosecutor's ability to control and manipulate a grand jury creates an inherent bias and leverage over what the grand jury can even hear, much less what they can do. Grand jury often has rights of subpoena, but they rely on prosecutors for when and how to do that. In effect, even with the grand jury in place, government abuse has gained an influential upper hand. But at least it's a start. But there's a group called the American Legislative Exchange Council. And on their website, they address this very issue. They call for reformation of the grand jury system, and they drafted a model plan in 2017 called the Grand Jury Due Reform Act. It's a model legislation. It has not been enacted. There's, to the best of my knowledge, no state, or I'm certain not the federal government, has ever enacted it. And I will provide a link so you can read the whole context of it at your leisure. But I would like to read, just because it summarizes so well the points. They talk about the legislative purpose and findings. And those are critical because it talks about the reasons and the justifications for reform. In their proposal, they say, Section 1, Legislative Purpose and Findings. A, the purpose of this act is to provide greater transparency, accountability, and fairness for the criminally accused during the grand jury proceedings. Of course, presuming that there is a grand jury proceeding. B, it is found that grand jury proceedings has traditionally been a means for the citizens of the United States to stand between the accused and an overzealous government. What have I been saying this entire podcast? It's about citizen oversight preventing abuse of power. They use the word overzealous government. I use abusive, corrupt government. It's the same thing at the end of the day. Government overreaching itself, government acting without proper due process, without due cause, simply prosecuting for the sake of prosecution, for whatever benefit they might gain. C. It is also found, as time has gone on, the grand jury system has slowly transformed into a proceeding that heavily favors the state, while affording few due process protections for the accused. Again, I was just talking about it, how prosecutors have this really an unfair opportunity to influence the perceptions of laymen who don't understand the law and don't understand the process, giving them advice and instructions on how to proceed. They oftentimes are the only source of information the grand jury receives. They control what the grand jury hears, they control what the grand jury sees, and unless you have an aggressive grand jury that overrules the prosecutor, which doesn't happen very often because, let's face it, most people don't realize they can, then you end up with a prosecutor basically using the grand jury as puppets. D. It is also found that many states have done away with the proceedings altogether in favor of a more open probable cause hearing before a magistrate. And once again, I must insist, Montana doesn't even have that. We don't even have that. There is no probable cause hearing. E. It is found that a probable cause hearing likely provides greater protection to the accused than a traditional grand jury proceeding does. However, in states that still allow or require grand jury proceedings before a criminal proceeding can continue, certain safeguards, transparency, and accountability measures are necessary to preserve an accused's due process protections. That's the part I'm going to read. Everything else is me. The point I'm trying to make here is that I don't necessarily 100% agree with the idea that a probable cause hearing provides greater protections because, once again, there's no citizen oversight. That you put it in front of a magistrate, a judge is often allied with a prosecutor who's a member of the government and doesn't necessarily hold true to the idea of impartiality. When you put the measure of guilt or innocence with one man rather than 12, you greatly diminish your chances, especially when that person has a pre-existing relationship with the prosecutors. He's an attorney, like the prosecutors are. He works with these people on a daily basis. He believes in the integrity, or claims he believes in the integrity of the prosecutors, and therefore he's going to be much more inclined to believe them over the protestation of innocence of an accused person who he doesn't know, who he's never seen before in his life, and may be accused of a pretty darn heinous crime of which the judge doesn't like. So, especially if that judge decides he wants to take a political platform, for instance, I'm anti-judge, I'm anti-wife beating, I'm anti-this, I'm anti-that. Whatever his personal, soapbox may be, if somebody's accused of something of which he personally doesn't like, it's automatically going to be that one person's bias and bigotry. It doesn't provide anybody better protection in a probable cause hearing because citizen oversight isn't there to check the powers of government. You might have a better opportunity, perhaps, to present evidence because more evidence will have been gathered by that point, but a grand jury has a much broader power. It has a much broader power to be much more inquisitive and inquiring, to subpoena witnesses, to bring evidence, and an individual who's brought before a probable cause hearing doesn't have that opportunity. They only are limited to whatever the prosecution presents. And they're able to sit there, maybe cross-examine the witnesses the prosecution brings, but it doesn't give them the ability to go out and find witnesses of their own, evidence of their own, innocence, facts that may prove their innocence. None of that is allowed. That's something a grand jury can sort through if given the proper capacity to act independently. The bottom line here is that grand juries are an absolute necessity for a fair democracy. They really are. For a free and fair democracy, you must have grand juries. And just like you must have citizen oversight at every level. A grand jury is critical to citizen oversight. But the state of Montana has shut off that right in its entirety. To provide for expediency in removing their own accountability, they've removed a constitutional prerequisite that the United States Supreme Court has said that all the states are bound to. And yet the U.S. Supreme Court will not revisit this case and revisit this issue. Montana officials have created a totalitarian state where only they hold power. And within that totalitarian state, you have someone like Mike McGrath who's trying to secure an independent judiciary so that his branch of government is completely autonomous. Citizens have no power if it all rests with corrupt officials like this. This is about citizen oversight and holding government accountable. So when does that happen? Once again, take this information and spread it amongst your friends, because this is how information develops. This is how we affect change, is we spread this information. We hear it, we listen to it, we absorb it, and then we pass it on. Like, subscribe, and by all means share this information. If you're watching this on YouTube, that's the procedure. This is actually spread out to about a dozen different platforms. So I can't guarantee that's the exact procedure you'll have on whatever site you may be watching this. Hopefully someone will take this information, and I strongly encourage taking this information, this video, and spreading this information and sharing it. By all means, I don't encourage plagiarism, but I do encourage taking this video and sharing it and distributing it even more widely. Share it on Twitter, share it on whatever social media platform, Facebook, whatever. Share it, get it out there, because only exposure can possibly ever bring these corrupt officials to light and bring an end to the Great Montana Conspiracy. As I say at the end of each video, once again, if you are watching this and you're not seeing the text attached to this video, by all means, visit us either on YouTube, the Great Montana Conspiracy Podcast, or visit us at monspiracy.podbean.com. The text will absolutely be there. And of course, if you want to support the program, the information for doing so is in that text. As always, please be safe, and whenever possible, please be free. Thank you.